Last offense was registered against the present petitioner. That is in the year of 2015, sir. So my humble submission, Your Honor, may kindly please to appreciate that after the act, there is no other offense has been registered.
After the
Act.
FIR is of 2020.
14/1/2020 ની FIR, સાહેબ. એ સાહેબ directly under the Gucci talk. Therefore, the Honorable High Court has considered for the other accused person that after the act, no offense has been registered. Therefore, they are granted bail, sir. Your Honor, may kindly please to see page number 11. એમાં સાહેબ આરોપી નંબર 1 તરીકે મારું નામ, 2 અજય, એમાં સેમ થિંગ કન્સિડર કરવામાં આવેલી છે. 3 રિંકુ, 4 જયપુરી, 5મો નંબર સાહેબ વિજેન્દ્ર, એમાં બી સેમ થિંગ કન્સિડર કરવામાં આવેલી છે. Therefore, Your Honor, may kindly please to see page number 59. That is the order of the Vijendra. Page number 60, para number 5.
Page number
60.
60.
60.
Yes.
I heard the learned advocate on behalf of the respective parties various papers. In present case, investigation is over. Charge sheet has been filed. Learned advocate for the applicant stated at the bar that there are no antecedents registered against the present applicant after the 2015, and more particularly, not a single offense has been registered against the present applicant after commencement of the Gucci Talk Act. Learned APP is not in a position to confront the said facts.
Yes.
So, after the act, I never been arrested. No offense has been registered. Merely present offense that is also under the Gucci Talk Act, sir. So, prima facie, Your Honor, may I kindly please to appreciate.
Yes.
Prima facie, whether the Gucci Talk is applicable in present offense against the present petitioner is debatable. As such as Vijendra Elias Lalo is facing a identical role is been considered, sir. So I am requesting this honorable court to consider my bill applications. Another thing, સાહેબ, એમાં એક અજય ગોસ્વામીને સાહેબ જે ગુજરાત હાઈકોર્ટે છોડવામાં આવેલો, તો એમાં બીજે કેમણે એવું કીધું કે 28/40/2024 થી અમે સુપ્રીમ કોર્ટમાં સાહેબ SLP કરેલી છે, કેસ ડાયરી નંબર આપેલો છે. સાહેબ એમાં 16 મહિના થઈ ગયા, 16 મહિનાથી અમે ડિફેક્ટ રિમૂવ નથી કર્યા. એફિડેવિટના ફ્રન્ટ નાના છે, એ મોટા નથી રિમૂવ કરે સુપ્રીમ કોર્ટમાં. સુપ્રીમ કોર્ટમાં 90 ડેઝમાં ડિફેક્ટ રિમૂવ કરવા તે ઓર્ડર પાસ થઈ ગયો, રીલિસ્ટિંગ માટે તમારે રિમૂવ કરવા પડશે, સાહેબ રિમૂવ નથી કરે એમણે 16 મહિનાથી, જાન્યુઆરી 2024 થી, સાહેબ.
You applied before Supreme Court?
ના, મારી ફર્સ્ટ બેલ. બીજાને જે નામદાર ગુજરાત હાઈકોર્ટે છોડ્યો એને અજય ગોસ્વામી સાહેબ, એમણે એફિડેવિટમાં પર્ટિક્યુલરલી દરેક વખતે લઈને આવે છે કે વન ઓફ ધ મેટર ઇઝ પેન્ડિંગ બિફોર ધ સુપ્રીમ કોર્ટ 28/40/2024. તો સાહેબ એનું સ્ટેટસ જોવામાં આવે તો સ્ટેટસમાં એવું જ કીધું છે કે ભાઈ અમે ડિફેક્ટ રિમૂવ કરો, જાન્યુઆરી ફાઇલ થશે, ડિફેક્ટ રિમૂવ 90 ડેઝમાં નથી કર્યા, સાહેબ રીલિસ્ટ ફાઇલ કરવી પડે એવી નથી કરી, સાહેબ એનું સ્ટેટસ મૂકી દેશે.
Cancellation file કરી છે.
હા, 16 મહિનાથી સાહેબ કેન્સલેશનમાં ઓબ્જેક્શનમાં મેટર મૂકી રાખી 16 મહિનાથી, એવું છે. એના પછી નામદાર ગુજરાત હાઈકોર્ટ રિસેન્ટલી બધા છોડી દીધા છે. Another co-accused also having any સાહેબ અનુરાગ ઉર્ફે ટાઈગર, જેની નામદાર ગુજરાત હાઈકોર્ટે નામંજૂર કરી હતી, પેજ નંબર 63.
આની પહેલી એપ્લિકેશન
પહેલી
2020 થી
2020 થી
ફર્સ્ટ
બેલ એપ્લિકેશન. અને નેમ એક્યુઝ ઓલ આર કન્સિડર બાય ધ હાઈકોર્ટ. જેટલા નામ જોગ છે સાહેબ બધાને મેં ઓર્ડર મૂકેલા છે, બધા છૂટી ગયા છે આની તો FIR માં. અનુરાગ ટાઈગરની સાહેબ નામદાર ગુજરાત હાઈકોર્ટે નામંજૂર કરી હતી, and any visa successive bail application has been considered by the Honorable High Court of Gujarat, considering the only single thing. સાહેબ એનું બી વકીલાતનામું મારી સાથે ફાઇલ થયેલું છે 2023 માં, એનું બી 2023 માં ફાઇલ થયેલું છે. પેરા નંબર 5 માં પેજ નંબર 64 ઉપર છે. પેરા
60 પેજ
64 અનુરાગ ટાઈગર, એનો ઓર્ડર છે પેજ નંબર 63 થી ચાલુ થાય, 64 માં સાહેબ કન્સિડરેશન છે. There, after 3 lessons, 64. The applicant has been arrested in connection with the present offence on 14/2020. Since then, the applicant is in custody, having regard to the date of his arrest and the this court-wide order dated 27/2025 has called for the report from the concerned trial court as regard the status of the trial. Accordingly, the concerned trial court has submitted the report regarding the status of the trial, in which indicates out of the 97, 13 witnesses have been examined as for remain. So he is considered on 19/3/2025, sir.
So your main contention is with regard to applicability of Gucci Talk.
Please, sir.
And secondly, the co-accused have been granted bail.
Granted. Co-accused also consider applicability of the Gucci talk.
Your Honor, sorry. If Your Honor should kindly say just to assess this honorable court. So to kindly see that as far as the present applicant is concerned, is the main kingpin of this organized crime syndicate. Said, if you want to see, said first bullet point, he has a colorful history. Said, open three offenses, serious offenses like loot, murder, attempt to murder, extortion. Not only that, said 22 offenses જે છે એ UP, MP, Rajasthan and Karnataka. So as far as this particular accused person is concerned, he is the kingpin. Now, sir, as if you want to kindly see, is reflected on the FIR. In the FIR, if you want to see, that page number 20. This is page number 15 onwards, sir. Just to correlate, yes, sir, as a list numbers you look at FIR much, where all these offenses are there, and these are conducted by mostly all the 8 persons. Sir, you know, I appreciate કે સાહેબ હાલના ઓફેન્સમાં ટોટલ 8 આરોપીઓ છે. 8 માં સાહેબ 4 જે છે એ જેલમાં હતા અગાઉના ઓફેન્સીસમાં 2011 થી 2015 ના ઓફેન્સીસમાં અને 4 જે છે તેના ફૂડ સોલ્જર્સ તે લોકો બહાર હતા જામીન ઉપર. So their modus operandi was અંદરથી મોબાઈલ ફોન the trial is going on, મોબાઈલ ફોન અંદરથી યુઝ કરી ટાર્ગેટ પિનપોઈન્ટ કરી બહારના જે ફૂડ સોલ્જર્સ છે એમના મારફતે જે છે ખંડણી કરાવવાની અને પૈસા એક્સટોર્ટ કરવાના મર્ડરની ધમકી આપવાની. સર એ સંદર્ભે ઇકોનોમિક્સથી એક સિક્રેટ ઇન્ફોર્મેશન મળ્યું when proper interception order was taken by the officers and they were listening to the talk. Emma said talk if you want to see said FIR machine. So just to see how this modus functions. બધામાં સાહેબ it is pertinent to note કે આ હાલનો આરોપી જે છે he is the instructor, he is the main person on behalf on instructions આ બધા જ નીચે કામ કરી રહ્યા હતા. સર આ ઇન્ટરસેપ્શન નું છે વિશાલ આરોપી સુરત ને કહે છે ઉઠ ગયા જેલ કે ઉઠ ગયા જરા उसका वहां सूरज हाँ जाता हूँ 50,000 ले लेना एक एक्सक्लूसिव वर्ड है उसके पास से लेट जाओगे तो चलेगा नहीं फोन करके ले लेना सेकंड फरीથી આજ સતત ડાયરીમાં પણ બધા વિક્ટિમ્સ ના નંબર અને નામ કે કોના પાસેથી કેટલી ઉઘરાણી કરવાની ના કરવાની તો મર્ડર જે લાડ સોસાયટીમાં કર્યો હતો એની રેફરન્સ આપીને ધમકા વિજેન્દ્ર ભોપાલ से आ रहा है 25 ले लेना उसके पास બધામાં સાહેબ સતત પૈસાની જ વાત છે પેલા પાસેથી 25 પેલા પાસેથી 50 so these food soldiers were collecting the money on clear instruction. I will not consume this all court's time. FIR must have transcript. Now, when the interception was going on, sir, I'll know offense. I'm sorry to say, my learned friend would lead to misleading of this honorable court. Very much there is an offense. This present offense. How does this come on surface? Sir, interception વખતે આજે ચાલી ગયું છે ફરિયાદી જે છે is a bullion trader, is a protected witness. એ એમના ઓફિસના અવર્સ પછી જ્વેલરી શોપમાંથી પાછા આવતા હતા ત્યારે 4 ઇસમ બે બાઇક ઉપર બે ગાડી લઈને બંદૂક એમને પોઈન્ટ કર્યો. બંદૂક પોઈન્ટ કર્યો તો પેલા ગભરાઈ ગયા સિગ્નલમાંથી નીકળી ગયા. ઇમિડિયેટલી ફોન આવે છે સાહેબ એ પણ રેકોર્ડેડ છે. આપને અભી ટ્રેલર देखा है, पिक्चर जल्दी देखने मिलेगा. Same mobs because he's a bullion trader. You will see the I will call you from Africa. Africa is nowhere. Ranipur, Central. This is your turn. I will call you પછી ફરીથી message. I will call you after 2 days. Till you are safe. अब तो तुम काम कर सकते हो बाद में देखिए. This is the genesis of the present offense. A clear syndicate being operated by the current applicant who is the kingpin on instructions the other accused persons. And in this light, I would kindly urge this honorable court to just base paragraphs of Marsha Mango's with your honest permission. So the main intent of this just it directly correlates as a said the organized crime has for quite some years now come out as a very serious threat to our society. It knows no national boundaries and it is fueled by illegal wealth generation by contract dealing, extortion, smuggling in contrabands, illegal trade in narcotics, kidnappings for ransom, collection of protection money. economic offences such as running of Ponzi schemes and multi-level marketing with a view to record the people for obtaining monetary benefits or large-scale organized betting in any form. It is noticed that organized crime syndicates make a common cause with terrorist gangs and narco-terrorism. Sir, second two paragraphs are important, sir. It is noticed that the organized crime syndicates make extensive use of, sir, wire and oral communication, clearly touching to the finer nuances of this case. In their criminal activity, the interception of such communication to obtain evidence of the commission of crimes or to prevent the commission thereof is inevitable and is an indispensable aid to the law enforcement and administration of justice. It said, now the reason why would see of the existing legal framework, the penal and procedural laws are adjudicatory system have been found to be rather inadequate. એટલું systematic કામ ચાલે છે કે that is inadequate to curb the control and menace of organized crime. It is therefore considered necessary to enact a special law with stringent and independent provisions, including certain circumstances, power to intercept wire, electronic or oral communication to control the menace of organized crime. So now, if you also tell me that not only the present victim, if you also see my bullet points, series of protection money. So there are several protected witnesses. If you want to see, say page 3 of my bullet submissions, the short synopsis, which is a part of the charge, just to assist this honorable process. Say page 3 ma to show not only this single episode of acting the bullet season, say again protected witnesses, all as per the instructions of present applicant.
So this he was operating from jail. So now then why, what? Then there's, if he operates his racket from the jail, what steps have been taken?
Sir, that is how the Arms Act and the Prisons Act
But that is again this accused person who facilitated these accused persons. Someone would have facilitated. Getting mobile phone in the jail is not an easy task. Now any jail authorities are.
Offenses under the Prisons Act as far as the mobile procurement.
But who is the accused? The only accused person who are already accused. And what about those facilitators?
That is also an area which sir hide કરીને લઈ ગયા છે અંદર. If you want to see last.
We don't know whether it was hidden or it was provided.
Such that it can be easily camouflaged with bodies.
But then what?
They often would, they use certain body parts to carry it.
They would do it. But then there are jammers.
I understand what is falling down from this honorable court, sir.
And the main.
Perspective. Sir, આમાં જે છે, sir, several instances છે. આમાંથી બધા જે જેલમાં હોય એમના પાસેથી બહાર છૂટી જાય તો પૈસા માંગે કે ભાઈ તું ફલાણા પાસેથી પૈસા લઈ લેજે. So these are all protected witnesses. Series of episodes. 2 lakh, 3 lakh, 50,000, 25,000. બધા પાસેથી protection money. Now if you want to kindly see one more thing. When the 4 persons were out on bail, post this interception and this bullion traders application for complaint, they went to arrest 3-4 persons and said residents super. They got a weapon which was used and 40 live cartridges which was recovered to Panchnama, and I said that is also there, which was used in this very crime, and the Honda City, which was used on rental basis, and the other electronic evidences as far as the use of telephone and everything is concerned, sir, that is also in my humble submission, the complete gang has operated in such a manner wherein they would threaten and extort monies, giving their record, past record of serious offences which they have conducted, so that a fear psychosis is generated in the minds of common man, and they somehow give the monies which were taken. So, sir, as far as
Now, what about parity and applicability of Gutsito?
I would understand. That one disturbing aspect, I'm sorry to use the word, is again the aspect of misleading that a promulgation પછી કોઈ offense ના. This is the offense. I understand. Past 10 વર્ષમાં સાહેબ જે criteria છે એમાં to be thoroughly fulfills the criteria. But as far as I also understand કે sir promulgation પછી કોઈ offense ના હોય so you can't wear the garland of Gutsito. કંઈક તો બનાવ હોવો જોઈએ, which was stated in the High Court judgment also. So sir આ જે છે this is a triggering point for us to invoke the Gutsito. So it is not the case कि 2015 પછી કોઈ offense, this is the very much offense. અને સાહેબ પાછળનું એટલું ખબર છે. Now coming to say parity and sir latest.
But as on date, the High Court's order stands.
Sir, I will go to that motion, no number 26. As far as parity is concerned, I am referring on 2021 6 SCC 230 that among bail, parity and gravity of offences, criminal antecedents of accused must be weighed for the purpose of granting bail. Merely observing that other accused was granted bail was armed with similar this thing is not sufficient to determine the case. As far as this person is concerned, sir, he is the main person on basis of which the other persons are dancing and getting his monies and work done. So, and with the fact of serious offences pending against him, so in my humble submission, the parity won't lie. Sir, as far as receipt of his concerned, which is paramateria to Makoka, sir, Amma 2025, if I want to kindly see Supreme Court, Registry Kana Bate.
Yes.
Sir, 11 para would be. Sir, High Court Makoka में जामीन आपकी दी थी, which was challenged with the Honorable Supreme Court. And sir, Amma ji से para 4, sir, certain important aspects. It is para 4 with orders commission. It is the core contention of the applicant that their petition of the interim order itself would bring home the fact that the order granting bill responded to 2 and 3 is an outcome of consideration akin to a mini trial. Sir, two dimensions were discussed. To what extent can the evidences be appreciated? Let's say Bama a point purchase subject and I will come to the other aspect also. Instances of observation partaking of characters or findings on merits of the case have been pointed out by another important question. It is further contention made of something that the irrecusibility of the duty to consider the living conditions of 21(4) of Makoka, which is parameter to 20 of good seat of set. Now, sir, relevant is para 6. There cannot be any doubt with respect to the position that Makoka is involved in the case of hand and accused of the so could not have sought for bail in exercise of the discretion available in the 439 CRPC. In the matter in view of rigors of section 21(4) of Makoka, a petitioner of the imperial order would reveal that the public prosecutor resisted the prayer for grant of bail and praised the court to consider the question of grant of bail, taking into account the rigor of 21(4) of the Makoka. In fact, the imperial judgment would reveal that the same contention was taken up by the High Court at the same time, because the fact that the imperial order did not reflect such consideration as has been required in respect of matter involving offences under Makoka in terms of the provisions thereunder, as also the decisions rendered by this court in respect of grant of bail. Sir, when there is an embargo put in by a specific provision under a special enactment in the matter of grant of bail in respect of offences allegedly committed thereunder, the power to grant bail should necessarily be subject to satisfaction to the conditions mentioned in the specific provision. In the case on hand, such a specific provision is contained under 21(4) of the Makoka. The learned counsel for the petitioner would submit that the bail was granted to say here sans considering their entitlement to view of the judicial. Again, Ramesh Thakur said they may parity to present. At the same time, the learned counsel appeared on the respondent would submit that even in the case of offence under PNLA, which carries similar rigor in the grant of bail, this court has held that such stringent provisions for grant of bail would not take out the constitutional right for grant of bail on so and so, but we may hasten to add that a critical examination of the imperial order would reveal that the bail was granted to so and so in the case of hand.
Yes, ultimately it was bail was cancelled. Now, what happened about it was remanded to the High Court for fresh consideration in January 20.
There is no. This is the last which I could then place my hands upon, sir, which is paramateria to proceed of 20 subclause 4. You kindly see. So, sir, now coming to the aspects as far as the submissions are concerned, my learned friend submissions are concerned. I'm sorry to say it amounts to misleading because that Ama paging in my this thing is not there. Fourth Page 5 of his petition, sir, ત્રણ મુદ્દાઓ જે એમણે કીધા કે 2015 પછી કોઈ offence નથી. I am sorry to say, the present offence is very much after 2015. Now, આ સાહેબ, the petitioner for the submitted no specific role, nothing is, sir, mobile એમની પાસે jail ઉપરથી મળ્યું છે. There are electronic
But,
evidences.
When you say you are sorry to say, there is also observation of the High Court. Admittedly, there is no offence.
I moved on, sir. So this is the offence under which the trial is going on. I don't know, यहाँ पर some submissions that I was not party to.
We are, see, you might be party, but prosecution was there
So the fact.
and bail has been granted. So, and that order is not been challenged, or that is not set aside. It is not set aside. But as per his submission, that objections are not being removed. So these observations stand as it is, as on date.
Now, if you also kindly see, sir, आज ये છે. Sir, the factual scenario still remains. Sir,
On those factual scenario, the co-accused are being granted. There is one observation which would apply at least for all. Okay, after after commencement of Gutsi talk case, there is no offence.
the fact remains.
See,
Sir,
the fact remains,
I have certain limitations, I can't jump, but the fact remains sound.
those
very strong and
limitation,
clear.
those limitation would also apply to this court also. When there is some observation of the High Court in the order.
Sir, 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 as we were not a party in the High Court, we don't know what was submitted from both the ends.
No,
But the
then
fact
that is
remains.
that is not an argument. That I would not consider. Okay, we were not party.
Sir, in that
Prosecution
case,
was there.
I would
Prosecution was there. So that argument I won't take.
Sir, I would harp on this thing that this amounts to misleading and there is an offence. We
But
cannot
see, if
harp
it
on
is
the
mis-
fact, sir. I didn't read the case के साथ ऊपर चलने बात कर कोई आमा तो सर FIR છે trial is going on. Which is
But
very
there
much
is
a
order of High Court.
Sir,
There is order of High Court. You can't say.
એમાં પછી
Observation by the Honorable High Court that there is no case pending, there is no case after.
But that is observation.
There is case.
this is the case.
But then,
Application, our submission is the matter is pending before the Honorable Court. Your Honor may note this submission. This
yes,
is
we'll note your submission.
Sir, one more time, which you also kindly say. Sir, Sandeep Prakash Gupta, your honors are aware, but still at the pains of repeating. F side, F માં લખ્યું છે, there would have to be some act or omission which amounts to organized crime after the act came in force. Again, I am in my humble submission supported by Sandeep Prakash.
That in co-accused bail matter,
Sir, in observation.
that judgment, Sandeep Om Prakash Gupta is also referred. Sandeep Om Prakash Gupta is also referred there.
Sir, એમાંથી જ વાંચી રહ્યો છું.
But even after that decision, the High Court has,
Then I pose a question to myself, sir, આ paragraph નું meaning શું રહ્યું?
then I would also pose question to myself, okay, whether High Court observation should be ignored by the court. Still as, it stand as it is.
Sir, now.
It is not that, it is not that okay, you were not there. Prosecution was there.
I put out, prosecution
Yes.
was there.
State.
State is there.
State is there. So you can't say okay, we were not.
State is there.
No, whatever it was. Ultimately, today that order is there, granting bail to co-accused.
Our submission, it is observation and the fact reading that it matter is pending before the Honorable. Therefore, your Honorable.
Now, when was your matter filed before Supreme Court? In which order? Ah. Pending. But ultimately, till date it is. So that factual aspect. You may, but as on date it stands.
Such, but the fact is, this is our.
You can buy. Yes, we will deal with your submission. We'll record your submission.
Sir, had it been the case, they said, very now or to the on surface, we are conducting the trial. for the-
No, you are.
This case, defense is submitting like this. If there is no case pending before the Honorable Court or there is no case after permanent. It appears that there is misleading statement.
In case of Ajay, co-accused Ajay,
Ah.
it is order dated 7/11/23. There also,
છેલ્લે જાણે છે છતાં નામદાર કોર્ટ રૂબરૂ જો આ સબમિશન કરે છે
They said that directly is under the Gucci law. There is no offense.
You-
Directly under the Gucci law.
What is this?
What I am submitting.
Sir,
દરેક કેસમાં હાઈકોર્ટે કન્સિડર કર્યું since જે પહેલો ઓર્ડર જે પાસ થયો છે ત્યારથી કન્સિડર કર્યું સર સુપ્રીમ કોર્ટમાં સાહેબ 17/1/2024 થી સાહેબ ડિટેલ લિસ્ટ અમને આવી ગયું છે હજી રિમૂવ નથી કર્યા 16 મહિનાથી એક જ વસ્તુ લઈને બેઠા છે ત્યારે કે ભાઈ મેટ્રિક્સ ગેનિંગ બિફોર સુપ્રીમ કોર્ટ That's the cancellation.
and submit people.
તમે ફાઇલ કરી સ્ટેટસ ફાઇલ છે આઈ નોટ ફાઇલ
As far as the situation is concerned,
but why would he go when you have filed your matter? See, it is your application.
Same submission sir નામદાર કોર્ટમાં જે submission I was there I have submitted before the honorable right.
sir,
But then-
pausing for a moment,
Same
sir,
is
I
reconsider.
would not do for a moment. Then what is the situation? The situation is there is an offense under which the trial is proceeding, witnesses have been examined, અને સાહેબ એ offense જે છે promulgation પછીનો offense છે. I would have no legs to stand in case promulgation પછી કોઈ offense ના હોય. Only on the background of other offenses, 49 colorful history, હું ક્યાંક આપી દઉં Gucci law. That is not, આમાં તો છે સાહેબ offense. And that is what Sandeep Om Prakash also says. કે સાહેબ એક offense હોવો જોઈએ promulgation પછી. That is the current offense. Along with their 48 history. And sir, one more surprising as all are from Madhya Pradesh outstation Modena. Sir, one of them jumped away. એમાં સાહેબ સુપ્રીમ સુધી ગયા હતા રિજેક્ટ થી વચગાળાની જામીન હાઈકોર્ટમાંથી લઈ નાસી ગયો. ત્રણ સરાને રિવ્યુના પ્રોસીડિંગ્સ પણ કર્યા છે સાહેબ. This person, in my own submission, stands on a separate pedestal altogether. He is the kingpin, orchestrating the entire events through him. I would have, as far as સુપ્રીમ કોર્ટમાં આરોપ રિજેક્ટ એટલે પછી એ જે છે વચગાળાની જામીન લઈને નીકળી ગઈ હાઈકોર્ટથી.
When it was rejected? When it was rejected? Yes.
સર 18/1/2024 સુપ્રીમ recorded an application for temporary bail from the High Court for 10 days and then he fled away.
Okay. So far as the aspect, two aspect is required to be dealt with. First, you are right, it is observation in bail application. We are deciding the bail application, not trial.
Yes.
So whether applicability of Gutsi talk or not, it was, even these are the orders in bail. So it, at this stage, we are considering the bail application only. The other accused persons are being granted. One of the observation,
One of them is absconding.
one of them is absconding after rejection of Supreme, by the Supreme Court. But these two aspects, even after this absconding, the co-accused has been considered. One ground, after commencement of this, there is no offense. Your case is that there is offense, this is Gutsi talk offense. But then, one thing. Second is with regard to parity, you may point out that this. In third order, in third order, it is observed that there are as many as this much witnesses. They are behind the bar since 20. We are in 25. So this aspect you have to.
Sir, in that context, just one submission. Sir, this matter started during the unfortunate time of Corona. We both were there. We also got Corona.
But
that being aside, sir, time and again, sir, the record will speak. Vakil Badalwani Arji, it might be their right. Sir, to the honorable court at that point of time, asked them several times. કે તમને લીગલમાં કે છતાં લીગલ પ્રાઇવેટ એ થઈ થઈને સાહેબ જે છે 23 સુધી સ્ટ્રેચ કર્યો How can we be put to,
But after all this thing, the High Court is considered.
as far as trial is concerned, trial is not delayed by.
No, it is not delayed.
And said, as far as, that is an observation of the Honorable High Court. And said, the fact remains that there is a offense, loud and clear, the serious nature after the promulgation of act. And said, releasing this accused will have serious consequences, have been my humble submission. He is a headstrong person and a main person behind the entire.
You
crime.
can go through those orders, because all this contention, while the bail application was of co-accused was opposed, the parity would not apply, considering the role. And trial is commenced, is in progress. That were the contention which were raised. Thereafter, his successive bail application is considered. So these are the things. But I will have it on